crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight for this half-hour discussion of legal matters that we believe are important to you, matter to you, and pertinent to you and your life. That's the whole reason we get together each and every week, and it's always better when you are with us. We have a panel of experts, going to introduce them in just a moment, but just a couple of the ground rules here in case this is your first time with us. We'd love to have you join our conversations. Several ways to do that. You can text us 205-670-1949, or you can call us at 844-529-8255. And as always, Hollis Wright makes available actual attorneys that are available. If you want to give them a call, some free, confidential, and off-air legal advice is yours for the taking throughout the program tonight. So pick up the phone and give them a call. Leading our conversation, he's the managing partner of Hollis Wright, Josh Wright. Good to see you, sir.
Good to see you, my friend. How are you?
I'm doing well. Thank you,
going
sir.
well?
They are.
Going your direction?
They're heading my way,
Good.
I hope. How about you?
We're doing great, Just loving the fall, and things are great right now.
Ready for the cool down, aren't we?
Oh, absolutely. There's no question about that. All right, so speaking of, not a great transition from cool down, but we're going to be talking about workers' comp today.
Right.
Courtney Brown is with us with Burge Brown here in town. When we have topics, and as you know, David, a lot of times we will bring in experts that handle certain areas and factions of the law that we don't do at our firm. We actually have one of our lawyers, one of our guys, Alwyn Horn, does some of this work too. But we bring in a lot of times experts that will be able to provide different information on the same topic that we've done in the past. But it's an important topic because it impacts a lot of Alabama workers. So first of all, Courtney, welcome for being on. We're so excited to have you. First time on the show, and we've had a lot of repeats, but she's the first time on the show.
That's
and
awesome.
We've had one of her partners on in the past, and has done some other discussions for us. But so comp is not something you've done your whole practice. This is kind of a new thing.
No, my
for you.
family has done FLA, which is railroad work injuries, which is a federal law, completely different from state workers' compensation law. And I just kind of got in this niche and have just enjoyed just the clients and helping them, and they're always in a bad place, and you just walk away every day just thinking how lucky you are that you're not in that situation.
How do you describe workers' comp? Because a lot of times people will call, and I'll take a call at our office, and it's someone that's been injured on the job, and they're trying to understand why they don't have a claim outside of workers' comp. So how do you explain kind of the workers' comp concept and the way it works?
Well, usually when a client comes into my office, I tell them very upfront that the Alabama workers' compensation laws are crummy, but I do that in a little bit more colorful language. But I let them know what they're in for. And I explain to them what is covered, and then look at the fact situation and see if there's any way, based on how they were injured, that there may be another claim that they may have outside of just the workers' compensation claim against their employer.
So Courtney makes a great point. As you know, I do a lot of co-employee work and also do a lot of third-party litigation. A lot of times what happens is someone's injured on the job, and they're bound to use workers' comp in order to resolve their claim against their employer, but there are other third-party claims or even some claims, co-employee claims under the workers' comp statute that allow you to pursue different avenues, different types of damages. And so we do a lot of that law too, and I know they also do, and they're always evaluating. But generally, from a workers' comp perspective, it's really almost a no-fault system, isn't it?
It is a no-fault. I mean, you can be, it can be entirely your fault, and you still get the benefits. It can be somebody else's fault and part your fault, like contributory negligence in Alabama. That is not a bar. You still get paid, but at the same time, if it's completely the company's fault and you're at no fault whatsoever, that does not change the law. You still will get the same thing as if the same benefits had you been 100% at fault.
How does one of the issues that comes up a lot is with general contractors, subcontractors. How do you determine whether or not somebody is actually an employee and subject to workers' comp?
Well, you look at their paychecks, you look at, I look mainly at their paychecks, and if they've had to sign any kind of contract, who they say that, they're employed with, who governs how they do their job. Yeah. That is a key thing. Whether they're a contractor or subcontractor, and that's ultimately how you figure it out.
And a lot of times, I'll get this question, I know we'll probably get it tonight, is, I'm on the way to work, and I'm injured on the way to work, but driving to and from work is not part of my job responsibility. Am I still covered by comp? And I'm not even asking that specific question, but you've got to evaluate really whether or not the injury itself arose out of the employment.
Yeah, it has to actually arise out of the employment. Those are kind of key words. And your example of going to work, no. If you're going from home to your job and you get injured, no. If you're going from home to your job, but your boss calls you and says, oh, by the way, go pick up, water at Walmart on your way here, then you get injured, taking that detour, then you would be covered.
Yeah. And are there some circumstances where comp is not going to cover you? For example, if you engage in intentional conduct, those types of things. There are a couple narrow exceptions.
And they're pretty obvious. I mean, if you're in the process of committing a crime at work, or if you're just horsing around and with a co-employee or whoever and get injured, or let me think of another one.
Well, one of the other ones is
intoxicated.
Yeah, that's right. One of the ones I see sometimes is intentionally impacting a safety guard. Or sometimes, trying to move a safety guard. A lot of times that will happen in our co-employee claims.
Yes.
We're trying to argue that someone has removed the safety guard.
Yeah, and if you remove something and you decide you're not going to use that safety guard, it's too much trouble, it's in your way, yes, that will be. But arising out of employment, one interesting thing is like assault and battery. So you go to work and Joe was flirting with Bill's wife the night before at a bar. So they get to work and Bill beats up Joe. It's about the bar incidents. So Joe's not going to be covered. Yeah. But the reverse, if Joe's not working fast enough and that's getting on his nerves, so he decides to hit him and it's because he's not working fast enough at the assembly line, then it would be covered. He would get benefits from being beaten up, for being slow.
And the stories you see, I know, are probably not. I know we're getting ready to go to break, but let me say this. When we come back, I do want to talk. I want Courtney to be able to walk us through what kind of benefits someone can actually get if they've been involved in an accident. Because the Comp Act, although there are some things that are crummy about it, the Comp Act does provide certain things and certain ways someone can get compensated. And I want to talk through that a little bit.
All right, let's step aside our first break of the evening. As we do so, this is one of those topics of conversation that really affect everyone. May want to call a friend or family member, let them know what we're talking about tonight. Would love to have them join us. A couple of segments remaining here on the show. Stay tuned. We've got more of the attorneys coming your way right after this short break. Stay with us, folks.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Hollis Wright is a proud sponsor of high school athletics.
Contact the winning team of attorneys at Hollis Wright if you need help after an accident.
Our law firm proudly supports Alabama high school athletics as well as the AL.com Hollis Wright Player of the Week.
Be sure to go vote this week for your favorite player at the Hollis Wright AL.com fan poll.
Welcome back into the Attorneys. About to jump right back into our conversation about workers' compensation. But first, just a reminder, attorneys from Hollis Wright standing by all throughout the program tonight. It's not often you get this great free opportunity, but Hollis Wright makes it available to you. All you have to do is give them a call, 205-670-1949 or 844-529-8255. Those are the numbers you need to know. Josh.
And don't remember 844 Law Talk, right?
844
we
Law
still
Talk.
got it's everywhere.
It is.
That's it.
Yeah.
All right, tell us a little bit about your practice. I want the viewers to understand a little bit about kind of what you guys do, because I know you do more than just workers' comp.
We do workman's comp. We do, like I said, we do railroad litigation for injured employees that are injured on the railroad all over the Southeast. We do FRSA, which goes along with the FLA, the railroad injury, and that is if an employee gets injured and is fired as a result of the injury while working on the railroad. There's a new, fairly new law that covers them, because for years, as soon as a railroad employee was injured, I mean, they knew they were fired, or if they didn't turn in the accident report because they were afraid they'd be fired, then they get fired for not turning in the accident report. So it's a vicious cycle.
That brings me to another interesting question is, if somebody intentionally fires someone because they're injured on the job, they've got potential recourse, don't they?
Correct. Alabama, as most people know, is an at-will state. You can be fired for a good reason, bad reason, no reason at all. But if you have filed a workers' compensation claim, it does not even have to be in litigation yet. As long as your employer knows that you've been injured at work and you are fired, then you have a separate action, which is retaliatory discharge. However, you have to be clean as a whistle to get through that. If you've 2 weeks before you got injured, you had a bad evaluation, that's a valid defense. If you were came back to work and after you're recovering from your injury, and you had 3 times that you clocked in and were late, even if it's like 5 seconds late each time, then they can get rid of you. Yeah. So it's tough.
Good news is you got folks like Courtney on your side that you can evaluate those cases to assess whether or not you can be successful.
A good question we've got here. This question says, I've been injured on the job. The question they have is, what type of benefits am I entitled to if someone has been injured on the job?
Okay, in Alabama, there are 2 types of benefits. There is your wage loss, and it's calculated by the employer goes back a year from the date you got injured and averages how much that was a week, and you receive 2/3 of that every week as long as the doctor says you can't work or you can't do your job, or you have light duty but your employer doesn't have anything for you and says, we can't do anything, go home, and you'll receive those benefits. Those benefits stop as soon as the doctor says you're at what's called maximum medical improvement, which most doctors know those buzzwords and know to put in their office notes. And when they say that, whether you can go back or not, your benefits, your weekly benefits stop. Then you have your medical benefits, and they are responsible, the employer's responsible for paying for your medical care, but you must go to their doctor. And if you don't go to their doctor, you choose to go to somebody on your own, they are not responsible for paying it.
Are there circumstances where you can, if you don't like the doctor that you have, you can work with your lawyer in order to get a group of other doctors as a potential? Right.
It's what's called a panel of 4. You ask for a panel of 4 because you either don't like your doctor, you get one shot at it then, or if the doctors recommend surgery and you don't want him to do the surgery, you can do it on that basis. And then the insurance carrier provides you with 4 doctors. They have to be of the same specialty that the one you're leaving is in, and they can't be in the same group.
And how do you settle these cases? Like, other than just your the 2/3 of your average weekly wage and your medical benefits, a lot of these claims settle and resolve, just like regular litigation.
Correct.
And in those, you're settling the workers' comp case itself. Is it based on a schedule? How's it resolved?
Well, the Alabama law has a specific schedule, and it's really a formula, and there's some leeway, but not a whole lot of leeway. You take the schedule for each body part has a number of weeks, and so the number of weeks is part of the formula. almost every body part is listed, shoulders, spine injuries or not, so they're a little bit different. You take that, you take their average weekly wage, and then you take what percentage of impairment or disability the doctor assigned to them. Now, if they've got restrictions and they can't go back to work because of those restrictions, making the same money they made before, even if it's in a different employer, then a vocational expert can assign a vocational rating, which is typically higher, and that's usually in shoulder and spine injuries.
What happens if you end up with a permanent injury? Are you compensated for the permanency?
Yes, if you're partially permanently disabled, then that was the formula I was just speaking of, and those can be settled out of court. They can be settled in mediation. Alabama and Department of Labor provides ombudsmans, which will mediate for free, which mediators can be expensive, so that's good for workers' compensation, injured workers.
Yeah, the fees are also set only at 15%.
The fees are set at 15%. They're set at that. Even if, and if you're in litigation and you settle, a judge has to approve it, because back in the day when they were being settled for really peanuts and taking advantage of employees that just needed to feed their family.
This is not the type claim that you want to go alone. You need to get counsel involved quickly.
Yeah. Another question we've got here says, I suffered a workplace injury. However, my employer told me I waited too long to inform them of my injury. Is there anything I can do?
There's a 5-day notice rule, written notice, but the courts but really it's 90 days, and the courts have been very, very lenient on that when it's been litigated, because employees just don't know. But the first thing you need to do when you even think you're injured is to report it. And even if you think you don't need to go to the doctor, you might need to go to the doctor the next day. People wake up the next day, they think their back's maybe put some Bengay on it, wake up the next day, can't get out of the bed. And they need to ask, who do I go to? Yeah. I mean, tell me now, if I decide to go to the doctor, who do you want me to go to? Otherwise, they'll do like I was talking about earlier and go to their own doctor.
I know we're getting ready to go to break. When we come back, I want to talk a little bit about what types of injuries are included, because it's not always just injuries to a specific body part. There are some occupational diseases and injuries too. We'll talk a little bit about that when we come back.
All right, we're stepping aside our final break of the evening. So the clock is ticking. If you want to join our conversation, we'd love to have you do so. Also, don't forget, you can always find Hollis Wright on social media. Just search Hollis Wright. Find them on Twitter, Instagram, Facebook, a great educational and informational resource. Stay tuned. We've got more of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. As with any industry, it's important in the legal world to hire an attorney that is knowledgeable and has a track record of success. But with so many attorneys out there and so many different types of cases, how does someone decide the right lawyer to hire? In this week's Legal 4-in-1, we're answering the question, what should I consider in hiring an attorney? In-state versus out-of-state, big firm or little firm, recommendations from friends or family, the internet, the phone book, or TV. With so many choices and so much information, it can be an overwhelming task trying to make the right decision. To complicate things, choosing a lawyer is an important and sometimes life-affecting decision and should not be taken lightly. So how do you select an attorney? First, do your research. Look the firm up on the internet. Learn about the cases they handle and the results they get. Second, find out what clients are saying about the firm. Many websites provide client testimonials or have a star ranking system. Use those to your advantage. And finally, talk with a lawyer from their office and ask them questions. Questions about the volume of cases they handle. Do they return phone calls? Are you just a number or a client that gets the attention you deserve? Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, A competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys right here on WVTM 13.
Welcome back into The Attorneys, our final segment. So just a few minutes remaining if you want to take advantage of that opportunity to speak with actual attorneys from Hollis Wright standing by live to speak with you. Just pick up the phone and give them a call. Josh?
Talk just for a minute, Courtney, about injuries we think of as an injury physically to the body. There are some injuries that aren't like a loss of a limb or a broken arm that relate to your pulmonary system and chemical exposures, those types of things. Is that fair?
Right. They're called occupational disease or repetitive motion injuries, and they are compensable too. The same benefits I talked about a moment ago. The only difference is instead of just saying it happened at work and they know it happened at work, they saw you fall off the ladder at work, there's no question about that. Instead, with an occupational injury, there's got to be objective evidence from a doctor, number one, medical evidence that you have this disease, and that the doctor also has to say that your job at work was the major reason that you now have this disease, whether it's pulmonary or carpal tunnel or whatever it might be.
Do you run into circumstances where someone has kind of a side thing, they do a side gig, so to speak, where they pitch on a baseball team and they have a shoulder injury or an elbow injury and they argue that it's from work? I mean, do you run into that a lot?
There's a lot of the employers always want to say it's from a pre-existing or something else other than work. But the Alabama courts have been fairly consistent in, if you were doing your job on the day you got hurt without any restrictions, then the pre-existing kind of falls by the wayside.
Gotcha. A question here having somewhat to do with the process of this, if you come forward with a workers' comp claim, do you appear before a jury or a judge, or how does the process,
if you, most employers have, they're either self-insured or they have a private carrier that covers their workers' compensation claims. So you deal with them, but if you have to file the lawsuit, then you have to actually sue the employer, which always freaks the client out. Yeah. And it's in front of a judge. There is no pain or suffering, so the judge knows the law and knows the formula. The difference in settling out of court and going before a judge, one of the big differences is if you settle out of court, then you can give up your future medical benefits, which, if you had your knee surgery a year and a half ago and you're doing great and you don't care, and you can, get a little bit more money in your settlement from that. But if you go in front of the judge will always keep your medical open for life as long as the doctor you're seeing is the doctor the comp carrier tells you to go to, and as long as he relates whatever he's treating you for back to the original injury.
I've always thought it was important to have counsel in these cases. I know some people try and do some of this stuff alone, but the reason it's important to have counsel involved in these cases is something you just mentioned, which a lot of times you're probably negotiating when it's time to resolve the claim about keeping the person's medicals open versus maybe they're not seeing the doctor as much anymore and we want to close those meds and it could increase the value of the case. I mean, that's kind of a leverage point, a negotiating point, isn't it?
That's probably the biggest negotiating point.
Okay.
Is if the clients will and can do that. Now, a lot of judges, here in Jefferson County, if you're a lawyer watching this, you know who they are. You better have a good reason to close your medical, and when you go up there with a settlement, to have the judge approve it.
Yeah. Let's talk for a second about the third-party litigation and co-employee stuff. We hadn't talked a lot about that, but there's a whole nother area of this law that I know you get involved in called third-party litigation or co-employee litigation. Can you talk just for a second about that?
Well, if you could be in a car accident and it's totally the other driver's fault, and you can have that suit against the driver. as well as your workman's comp case if you were doing, you were driving for work. You could be using a defective product, and there could be a products liability claim. You could be working a construction job, and another contractor, one of their employees did something that caused it. So there's several. However, if you do win on any of those claims, and you also got your workers' comp benefits, then you don't get to double dip.
Yeah. Although they do get some set-offs.
They do get some set-offs with attorney fees and
like
expenses.
Courtney was saying earlier, there are some leverage points, though, and there are some ways as a lawyer that comes in those cases that you have the ability to negotiate around some of the payback requirements that you've got. So it requires having a litigation team in place, and Courtney's firm's a great, Burge Burge, great example of folks that can help you if you run into these jams.
We have less than 2 minutes remaining in the show, just time enough for a final thought. And Courtney, if you would, you go first.
Well, I would just tell anybody that thinks they have a workman's comp claim, or anybody that works, period, to keep in their head that they need to notify their employer as soon as they think they even might have injured themselves that day. Find out at that point, who do I go to if I need to get medical help? Look at your wages for the last year, and if they start giving you weekly benefits, see if they're correct. And really, it's not a huge fee. It's set, the legislature set it for 15%. To get a lawyer who knows what they're talking about, and don't wait till you've gone to a doctor who is horrible and is about to do surgery on you, and you're just stuck.
Right. Yeah. Two things I'd say is hopefully there'll be some adjustments and changes in the workers' comp law. Some of the caps that we have are low. Hopefully those will change over time. But make sure you get to counsel early, because in many of these circumstances you've only got 90 days to report your injury. You want to make sure you report it, and go to a lawyer that understands this law, like Courtney and her firm, to make sure they evaluate the whole case. There may be a removal of a safety guard. There may be a third-party case, and just a comp case. Let them evaluate it for you.
Yeah.
Good job.
Advice.
Awesome.
Appreciate you guys being with us. Courtney, Josh, thanks so much for your time. And as always, thanks for your time as well. We really appreciate it. As we wrap things up, you can always head to the website. Just search Hollis Wright, find them, and get in touch with them. They would love to hear from you. Thanks again for joining us. We'll look for you next time right here on The Attorneys. Have a great week, everybody.
Thanks for watching The Attorneys, sponsored by Hollis Wright.